organized by the Forum of Religious for Justice and Peace on the topic Franco case, a critical assessment of the judgment. The program of this webinar will consist of the following. We will start the program with a silent prayer for 1 minute. It will be followed by welcome address by Sister Dorothy Fernandez, the national convener of the forum. She will also introduce the first speaker, Advocate Rebecca Mammon, a practicing lawyer in the Supreme Court of India. Advocate Rebecca will speak for about 20 minutes. It will be followed by clarifications for 5 to 10 minutes. The second speaker, Advocate Manu Sebastian, will be introduced by Father Anand IMS. Advocate Manu Sebastian also will be speaking for about 20 minutes, followed by clarifications for about 5 to 10 minutes. The program will be concluded by vote of thanks proposed by Sister Shanti.
I'm in a webinar.
With this brief introduction, let us start the program with 1 minute silent prayer. Let us all be in a prayerful disposition. With God's blessing, let's open our hearts and minds to understand truth. Let me invite Sister Dorothy Fernandez to introduce our first speaker, Advocate Rebecca Mammon. Dorothy Fernandez is a social activist and has been an active member of the forum for about 3 decades. Dorothy, please.
Thank you, Jacob. Good evening, dear companions, sisters, brothers, and friends. It's a privilege to welcome you to this very important webinar in the wake of the verdict pronounced, which has saddened and invited us as forum members and concerned citizens to express our solidarity and support to the cause of justice. Let's stand together as one voice to speak for justice and act for justice. Thank you for joining us in this evening. We are very privileged and fortunate to have in our midst 2 very renowned advocates. Their generosity to be with us when I contacted them speaks volumes of their commitment. So without wasting any more time, you will hear from them about their commitment to the cause of justice. And so, when I asked Rebecca Mammon, Madam, how should I introduce you? She said, Sister, just say I'm a criminal lawyer who practices in the Supreme Court. Though she has worked on many, many cases, we know that. So, Advocate Rebecca Mammon, welcome to you. Thank you for being with us.
Thank you, Sister Dorothy. There was some problem at my end, so you might have seen me exiting from one equipment to another. I think we fixed it. Thank you very much for giving me this opportunity to speak. I'm deeply honored that Sister Dorothy contacted me to speak on this verdict, a verdict which is of critical importance, not just from the point of view of the provision of rape, from the point of view of the rights of a victim, but also it is important because what is at stake here is the interplay between a dominant person and a subordinate, for which the law is actually harsher and which has been completely disregarded by the trial court in its judgment. This is a case, the facts of which most of you would be fully aware of, and I don't want to go into details of the facts. Suffice to say that the complainant made a complaint to the police on the 27th of June 2018, pursuant to which an FIR was registered. The complaint detailed 12 instances of sexual assault against a person who was in a position of authority. After investigation, the police filed a charge sheet, and pursuant to the filing of the charge sheet, a trial was conducted, based on which this verdict came out on a few days ago. I think it was on the 14th of January, 2022. What is critical when we examine this verdict is the following. The law on examining the witness, the evidentiary value of the statement of a witness who complains of sexual assault is different from other ordinary criminal law, in as much as the Supreme Court of India has repeatedly stated that when you look at the testimony of a rape survivor, you must be conscious of the fact that very often she will not have any corroborative evidence. And even if she has corroborative evidence, that evidence will be in bits and pieces. Because of the nature of bodily assault, victims have problems about confiding in others about what she went through. So a rape survivor's testimony is always viewed differently in courts than the testimony of any other witness who stands as a witness in a criminal case. The ordinary yardstick of a criminal case is that you have to prove the case beyond reasonable doubt, and the prosecution has to prove the case beyond reasonable doubt. But in a rape case, there has been a slight shift in evidentiary standards, in as much as several provisions have been brought into play, which seeks to protect the procedural and evidentiary rights of the rape victim. And therefore recognizing the fact that a rape victim very often has nothing but her own words to corroborate her version, has to be looked at from a very different evidentiary standard. And so the Supreme Court has repeatedly reminded us that the manner in which we examine the testimony of a rape victim is as follows. If the rape victim's testimony taken as a whole is of sterling quality, A, you don't need corroboration. B, the court must accept that testimony and not differentiate the testimony.
Rebecca, Mrs. Rebecca, your voice is less. Voice is reduced, not audible. Can you see whether something is wrong?
Would Manu like to speak first? I can.
Now it's okay. Now it's okay.
Is it better?
Now it is better.
All right. Okay. I'll
Okay.
probably do what I do in courts, and that is shout.
Okay. Okay.
Okay. What I wish to submit is that the testimony of a rape survivor has to be viewed very, very differently from the testimony of any other witness in a criminal case. The testimony of a rape survivor, if found to be credible when taken as a whole, must be treated at a footing different from the testimony of any other witness in a criminal case, because in rape cases it is very difficult to find corroboration. So that is the fundamental rule of evidence when you examine the testimony of a rape survivor. When I read the judgment of the trial court in Kottayam, what I find is that the judge has put the rape survivor on trial instead of the accused on trial, and has gone about nitpicking and disbelieving her in a way in which it is impermissible in law. The court, for example, spends a lot of time dissecting the evidence of prosecution witness 1, who is the rape survivor herself, and coming to the conclusion that she's not credible simply because she did not state the full extent of the sexual act at the time when she made her first information report. I am again getting messages that no video and no audio. Is that correct? I don't know what is happening.
Audio, we can hear audio.
Okay.
Rebecca, okay, you go on, speak.
Yes. So therefore, the testimony of PW1 was dissected in a way which is impermissible in law, simply because the witness did not confide the full details of the incident to PW2, another sister, and to 2 other sisters. I think they were PWs 4 and 5, prosecution witnesses 4 and 5, does not mean that her testimony or her evidentiary statement is of less evidentiary value. Fundamental mistake number 1. Even if she had not confided in anyone, the law is that if you find her testimony to be credible, you do not need corroboration. The fact that she confided in 3 fellow sisters only corroborates her version that she was subjected to sexual assault. What the judge then does is, in fact, he dissects her evidence and says that the full extent of the sexual assault was not told to PW2. Now, I am asking myself a question as a criminal lawyer who has practiced in this field of law for 34 years. Where is the need or the obligation, either in law or on the facts of a particular case, for a witness to confide the full extent of the sexual assault to anyone other than the court? The fact that she mentions briefly, peripherally, with some details about the incident to 3 sisters is sufficient. And to my mind, that was enough to prove that she was a credible witness. And the court fell in serious error by making this kind of dissection only because the extent of sexual assault was not told to her corroborating witnesses. The court failed to take into account the position in which the prosecuting witness complainant was placed in. The prosecuting witness complainant is a nun staying in a convent, having taken an oath of celibacy, also taking into account the hierarchical nature of the power differential. This was a deeply, deeply problematic and difficult story for her to tell. And if she came out and gave a comprehensive version in her first statement to the magistrate, that is the 164 statement, that should have been treated as the end of the matter. There is no obligation on her to tell all the individual facts of the assaults to everyone she speaks to. The trial court fell in error to empathize with the position in which she was placed, the position in her convent, the oath of celibacy, the fact that she was dealing with her superior, and the consequences of speaking out, which she and she alone bore, along with the 3 incredibly brave sisters who stood by her and came to court and prosecuted her and helped her in prosecuting the accused. So I think these fundamental errors were made. The other thing which the court fell in error was when the court examines her first statement made to the police and dissects it. The law on this subject is that the FIR is not an encyclopedia of facts. It simply has to lay out the broad parameters of the offense, which was laid out by her. She did not have to go into the details of the incident in the FIR. She had to just lay out the broad fundamental parameters of the incident. The details of the incident was a matter of investigation, where the police could have asked her questions and she could have responded. When the sister felt comfortable before a magistrate, she gave the full and complete version. Therefore, to nitpick and to discredit the testimony of PW1 on the basis of insufficient material given at the time of our first information report, to my mind, was wholly unnecessary, bordering on illegality, certainly showing no respect for judgments of higher courts, including the Kerala High Court. The other thing that we must remember when we examine offenses of this nature is that after the 2013 Criminal Law Amendment Act, which came into being pursuant to the Nirbhaya incident of December 2012, where the entire rape law was rehauled, several provisions were added to the category of aggravated rape. And one of the provisions was Section 376F, which reads as follows: whoever being a relative, guardian, teacher, or a person in a position of trust or authority towards the woman, if he were to commit rape, it would be treated as aggravated rape. Lawmakers were conscious of the fact that in several custodial situations, the woman is placed at a disadvantage, either by virtue of the fact that they are in a police station, or by virtue of the fact that the person they seek to complain against is in a position of trust and authority. And therefore, making a complaint is that much more difficult. If in such a situation, a woman alleges rape, it comes within the four corners of 376(2), which is an aggravated form of rape. The judge completely glossed over the issue of the accused being in a position of trust and authority and made use of farcical, illogical, and completely untenable arguments to even come to the conclusion that he was not in a position of trust and authority. I find that deeply problematic in the judgment. And I find the approach of the judge not just insensitive, but completely contrary to the statutory requirements of Section 375 and 376, which defines rape, as well as the law laid down by the Supreme Court. So clearly, This is a case, as we are seeing in case after case, where women complain about rape. This is a case where the court had put a woman on trial, whereas the whole purpose of criminal proceedings and a criminal trial is, one, to ascertain the truth, and two, to put the accused against whom the charge has been leveled on trial. By discrediting the woman in this manner, a very grave disservice has been done. It is not my case as a criminal lawyer that in a given case, an accused should never be acquitted. Of course not. What I wish to say is that while marshalling evidence, if a court comes to the conclusion that the prosecution has not crossed the threshold of proof beyond doubt, they must acquit. However, while assessing the evidence of rape survivors, the courts must be conscious of the quality of evidence, the nature of corroboration, if there is any corroboration, and the position in which the victim was before passing a value judgment on that person's evidence. In this case, the reverse happened. It appears that there was a predisposed, predetermined mindset that the accused had to be acquitted, and therefore every effort was made to discredit the testimony of a very, very brave woman, including 3 of her corroborative witnesses. Even when PW6, a relative who for some reason, had laid an allegation of sexual misconduct on PW1, the complainant in question, the judge chose to believe her earlier version rather than the version she gave in court, which was a version on oath, where she said she had lied earlier under pressure and that she was speaking the truth now. This is why I said it was not the accused on trial, it was the victim on trial. And by doing that, I'm afraid this court has overturned criminal jurisprudence, has completely disregarded the law of the land. And this judgment is a travesty which needs to be challenged, robustly challenged. And I'm fully, I hope and I pray that the Superior Court, that is the High Court of Kerala, will look into it and will overturn a judgment which is clearly a travesty. Thank you.
Thank you very much, Mrs. Rebecca, Madam. You have clarified, clearly mentioned what are the flaws in the judgment. You said the victim is on trial.
Yes.
So now we have 5 to 10 minutes for the participants of this webinar to ask clarifications. You are welcome. Those who want to ask questions, please press your reaction button and your hand will be appearing. We will unmute you, sorry. Then you can speak. Okay. Eulalia Pereira.
Yes, I don't have any question, ma'am, but I'm really, thank you so much for standing for all of us. I'm a sister myself, and it means so much to me that you have a stand for sisters. I have how do we support her further? Because this is not a case for one person. This is a case for all women. And this is, and though on the one hand, as a sister, I say we need to look at ongoing formation. We need to look at the quality of formation imparted. We need to look at the soft skill training that is given to priests and sisters in early formation. That's one dimension that, ma'am, is important. Equally, standing for the sister is also important. So how do we go about doing it together? Like I'm not a judge, I'm not a lawyer, I'm just a simple person. So how do we stand together, not just for her sake, but in standing for her, we're standing for all women.
Absolutely. I'm so grateful that you've said it in such a beautiful way.
Can't hear
I
you,
think
ma'am.
solidarity. I think solidarity for victims is very meaningful, and very often victims, particularly victims of sexual violence, do not get solidarity in our country. The fact that all of you, despite the constraints of the constraints within which you're all placed, have come out and organized this webinar, is itself an expression of solidarity. I cannot underscore the importance of what you have done today. This is very, very important. The fact that each one of you from your respective places have come out to stand in solidarity with a fellow sister is something I find deeply, deeply touching and heartwarming. And when Sister Dorothy reached out to me, my first response was that I will attend this webinar because I want to partake in this expression of solidarity. As far as she is concerned, as you are aware, many of the people who stood by her also faced backlash, in sense that they faced transfers and all manner of other backlashes. I think it's an ongoing struggle. It's an ongoing process where you need to write to people in power. You need to have conversations within the church. You need to tell everyone that while we are here on a particular mission, the bodily autonomy of a woman, albeit a nun, cannot be disrespected. You cannot take away the agency of a woman, and you cannot violate her bodily autonomy in a way that constitutes a crime. You cannot do that. Any act which is consensual, the law says that the long arm of the law will not reach you. But the minute a victim says, you cannot touch me, the matter ends there. And it is the fundamental right of every woman, now that the Supreme Court has come out with a 9-member bench judgment in Puttaswamy. It is the fundamental right of every woman to her privacy, to her right over her bodily autonomy. And if she has an expectation that that bodily autonomy must be respected, then if it is not done so, it is a serious crime. Therefore, this conversation must not end only with what has happened with this complaining witness. It must be happening to other women as well. And this must result in a structural conversation within the church where you ask people who are in charge to formulate guidelines, rules that prevent misuse of power in the manner in which the power and hierarchy was misused. You see, it is pretty evident when I read the statement of the complaining witness that she had made every effort to bring it to the notice of people who were in positions of power within the church, that this grave wrong had been committed on her. And yet, nobody paid heed to it. Whitewashing uncomfortable truths is not the way to move forward. An expression of solidarity is very important, but equally important is challenging these structures of power. And I think you can do that in a respectful way within the church and start a conversation, because one woman's struggle is the struggle of anyone who respects law, who respects justice, who wants that at the end, every wrong should be corrected. That's the only reason why we are here. And so I would say, extend your solidarity beyond the personal. Take it up within the church. There have to be structural solutions to problems like this, and not just lip service. Because unless you have guidelines, let me give you an example. In 1997, when there was a vacuum in the law, the Supreme Court of India made a landmark judgment. That judgment is commonly called Vishaka versus State, where a woman from a lower caste community in Rajasthan had complained of gang rape in the context of her workplace. And the Supreme Court took it up and said that the abuse of a woman at the workplace is a serious crime, and we need a law. Until such time as a law does not come into place, these are the guidelines, so that a woman's dignity and her autonomy at the workplace is not violated at any time. Therefore, I'm using that case only to say that within the church, within the Catholic Church or any other religious institution, or for that matter, any other institution, there must be institutional systemic change. And unless there's institutional systemic change, you will see this happening again and again and again, because you have to challenge impunity, and you have to say that a woman's autonomy, bodily autonomy has to be respected. There are two things. We are challenging power and impunity, and we are bringing out a message that her bodily autonomy must be respected at all costs.
Thank you. Thank you very much. We will have one more question. Nina Joseph, please unmute and speak. Nina Joseph.
Okay, wonderful presentation. I don't know, I feel I have no words to describe that, with what passion you are delivering it. And congratulations to the organizers for bringing such a person to our midst. I just have 3 points to make. One question: is prevention of sexual harassment in workplaces equally applicable to all church structures? If a murder takes place in a convent or anywhere, it is the criminal law which comes into action. So why should they have separate arrangements within the church? I happen to read one such law, that is, if a woman is in a vulnerable position like disabled, they can proceed, something like that. It is very odd. Second thing is, so post should be applicable. That is something which we should strive for. If anything happens, they have the system in the state. They should follow the law of the land. Another thing is that there should be more awareness regarding the behavioral aspects of a sexual rape victim. What does she do as the first response when there is a rape? Is it only fight and flight? Is there not the freeze as well? The autonomic nervous system. So there are a lot of things in behavioral science and neurobiology that there should be a widespread knowledge about that aspect within the church and also in the wider society. And the delayed response is often raised as a point. So why the delayed response? We have very beautifully put the power relationship. The bishop was asking the nun to iron his clothes. So in the judgment, we see that she's a responsible person and she is the mother general. She is not a lay person, but she is very powerful. So I think the power, what is the power she is having when she has to iron the clothes? So these 2 points I have to, okay, thank you. Regarding the post, please clarify.
Yes, so that would be, strictly speaking, the act would not apply because you have to first then declare that working within a convent or church is your workplace. but nothing prevents you. And I noticed that with a lot of organizations now, they use the POSH Act even to make the provisions gender neutral. Although the provisions of the POSH Act are in favor of the woman employee, but there are many organizations which have made it gender neutral. So assuming a woman is in a position of power and she is harassing, say, a subordinate male or a transgender person or somebody else, then even then organizations have used the framework of the POSH Act to have guidelines against that kind of harassment. In this case, the criminal law process was set into motion. So to say that the criminal law process was not set into motion is not right. An FIR was registered, a charge sheet was filed under rape, which is far, far more serious than the Prevention of Sexual Harassment Act. Let us call out the offense for what it is. As far as the applicability of the POSH Act within the larger church community, I think that's also a conversation which the church must have, because after all, how do you protect nuns and other members of the convent from day-to-day harassment if you don't have guidelines, if you don't have a list of do's and don'ts? Pursuant to several Supreme Court judgments, at least police stations in Delhi on the top has, this is what a rape victim is entitled to. Whether they follow that law or not is another issue. But I think we should have a list of do's and don'ts. When a bishop comes visiting a convent, what can he ask for and what is he not entitled to do? A list of do's and don'ts are very important. You can borrow from the POSH Act, but let me also remind you that this was a far graver offense where section 375 and section 376 of the code were invoked. This was a case of rape.
Okay, thank you so much.
So we don't have time for further questions, but if Rebecca Madam is available,
I will stay on, don't worry, I'll stay.
After listening to the second speaker, we will get opportunity. Okay, thank you very much.
Thank you.
Now let me invite Father Anand IMS to introduce Advocate Manu Sebastian. Anand, are you available? Father Anand? Father Anand IMS, are you available?
Jacob, maybe I'll introduce if Anand is not around.
Okay, yeah. You can introduce.
So very welcome to this webinar, Advocate Manu Sebastian. He's a native of a place in Thodu, Puza in Kerala. He's a law graduate from Symbiosis Law School in Pune and practiced law in the High Court of Kerala for 8 years. Since 2019, he has been the managing director, editor of LiveLaw, India's prime legal news portal, and has written several articles and commentaries on important legal developments. And his articles have earned widespread recognition among the legal circles. Welcome to you, sir, and happy to have you with us this evening.
Thank you, madam. Good evening, everyone.
Good evening.
So, Senior Advocate Rebecca, ma'am, she has explained what all are the flaws in the judgment which acquitted Bishop Franco in the rape case. So she has articulated brilliantly which are all the problematic areas in the judgment. So I don't need to add much. I'll just add 2 more points to what Rebecca ma'am has said. So there is another fundamental problem in the judgment, which is that in the Indian evidence law, we follow a principle that even if a witness is saying some things which are not believable or exaggerated, that does not mean that the entire testimony of the victim or the witness should be discarded. This is a fundamental principle which the Indian courts have been following for a long time. This is a well-settled principle. And this principle is based on a very commonsensical understanding that no person will be able to completely recount what happened few years ago. There will be some lapses in memory. There will be certain inaccuracies because a criminal trial will be happening several years after the incident of crime. So over the course of years, there will be certain memory lapses. For example, even we can think, we may not be able to recollect what exactly where we were doing last week at this point of time, or what the conversation we had with our friend a month ago. So that is impossible. That is unrealistic. So that is why we have this principle that even if a witness is saying some things which are not believable or which may be false also, that does not mean that the evidence has to be completely thrown away. So the courts have the duty to separate the grain from the chaff. It is the duty of the court to find out the elements of truth in what a witness is saying. And in this case, it is my humble opinion that, with all due respect to the court, I'm saying this, the court has failed to do that duty. The court has failed to extract the elements of truth from the testimony of the victim. By citing certain inaccuracies, by citing certain exaggerations or certain hiding of facts, the court has completely disbelieved the testimony of the victim as well as the testimony of the other witnesses. So Rebecca ma'am had explained that since the victim had not explained in graphic detail the sexual acts, the sexual crimes committed against her, because in her testimony, in her disclosures to other nuns, as well as to the complaints made to the other church authorities, the complainant nun was saying that she was being forced to share the bed. And all of us can understand, we are all people with common sense and basic understanding of human contact. We can understand when a person says that she is being forced to share the bed, we can understand the implication of that statement. It is very commonsensical, it is very understandable. However, here what the court says is that it is very surprising and it is very shocking, in fact. The court, in fact, I felt that after reading that judgment, I felt that the court took that statement, sharing the bed, being forced to share the bed, quite literally, without understanding the intent with which that words has been used. What the judge is saying is that when you are making a complaint, then you have to make the complaint or you have to make the disclosure in legal terms by using all the statutory definition of the rape. Section 3, you have to speak in the terms of Section 375. No woman would be doing that. That is, in present circumstances, it is very understandable. Nobody, even the word rape itself carries a lot of stigma in our present social setting. So they would be using other terms, and the judge should have been able to understand that. So merely because this word rape or the statutory definition of rape was not used in the complaint, in the disclosures made by the nun, the court is disbelieving her. The court is saying that there is a contradiction. Court is saying that there is an improvement in her statement. And this is cited as a reason for the court to disregard the testimony of the victim, as well as which was corroborated by three other persons, three other nuns. I'll illustrate with an example. One witness, one sister, she had come forward. Her name was Sister Lizzie Vadake. She was examined as PW2. And she is a very crucial witness. I'll tell you why. Because as per the complaint, the incidents of sexual crimes, sexual atrocities by the bishop started happening in September 2014. And it went on till September 2016. So in September 2014, there were two incidents of sexual assault by the bishop on September 5, 2014 and September 6, 2014. And there are records that the bishop had stayed in the convent premises on those days. There are clear evidences. And the bishop even had put up a defense of alibi. The bishop had pleaded that he was elsewhere on those days. The court rejected that alibi as well. So it is clear that the bishop was there on those days. And by the end of 2014, the victim, she makes a disclosure to Sister Lizzie Vadakale that the bishop had committed atrocities against her. And Sister Lizzie, she is belonging to another congregation. She is belonging to the FCC congregation. So she came before the court and she corroborated that fact. And the court disbelieves her. And you know what is the reason the court says for disbelieving her? The court says that if so, the victim nun, she had described Lizzie Vadakale as her spiritual mother. So the court is saying that if she is actually the spiritual mother of the victim, then she would have disclosed all the subsequent events of sexual assault as well. So she was only told about the sexual assaults which took place on 2014. And she was not told about the sexual assaults which took place in 2015 and 2016. So this is cited by the court as a ground to disbelieve her. I mean, I find this is very unbelievable. This is very shocking. I mean, it's a very casual manner in which you are discrediting a witness. And another reason cited by the court is that, so this sister, Sister Lizzie Vadakale, so she had to face a lot of hostilities and disciplinary action from her convent for coming before the court, for making the statement before the magistrate. So she had, in fact, written a letter to the congregation authorities, deliberately making certain false statements because she wanted to conceal that she was going before the magistrate to make a statement. Because if she's making that statement, then she'll be thrown out of the convent. So she wrote a letter to the superior saying certain other things. And this letter is cited by the defense to say that this sister is lying. And the court accepts that. The court failed to understand that the sister was making certain deliberate false statements to ensure her survival within the congregation. That fact was totally disregarded by the court. And there is another fact, because this letter, which was sent by Sister Lizzie Vadakale to her superiors in FCC congregation. Remember, this congregation is not within the jurisdiction of Bishop Franco Molekil. So this letter reached the hands of the defense lawyers of Bishop Franco. So this explains the influence and the reach and the clout of the accused. And this is very evident to even a common person. But unfortunately, the court, the judge who is a judicially trained person, who is supposed to be a judicially trained person, the judge is not able to understand this. Judge is not able to understand this power differential in the case and the influence which the accused is having and the challenges the witnesses, the prosecution witness nuns, they had to face to come before the court and to depose before the court. So on these grounds, Sister Lizzie Vadakale's testimony was disregarded by the court. And remember, so you just need to prove only one instance of sexual crime to secure a conviction. You don't need to prove all 13 instances. It is true that the sister has alleged 13 instances, but you just need to prove only one case, one instance. That is enough for conviction under Section 376. And the sisters, so Sister Lizzie Vadakale's testimony was corroborating the fact that the bishop had stayed there and that the victim had disclosed to her that she was subjected to forcible sexual acts. And that was completely disregarded by the court. And likewise, the testimony of two other nuns, Sister Anuvama and Sister Nina Rose, they were also disregarded by the court, citing that the sister had told them that the bishop, if the bishop comes, then I'll have to share the bed with him. This is what the sister had told them. And the court says that, so that does not mean that the sister was in fact raped. She only said that she will have to share the bed with him. This is how the court approaches. This is how the court takes a very literal sense. Court is taking the words in a very literal sense and taking a very hyper-technical and narrow-minded approach to disregard and discredit the witnesses. That is one aspect. Another aspect is that Rebecca ma'am had also explained, her character was put on trial. She was a lot of other things, a lot of extraneous things was placed on record to prejudice the minds of, to prejudice the character of the complainant. The court, I mean, if you read the judgment, there are several paragraphs devoted in the judgment to explain the complaint made by a relative of the sister. And that relative told before the court that that complaint was false. So that relative was a person who has made at least 2 inconsistent statements. So she should have been completely disregarded as untrustworthy. But the court takes extra efforts to believe her. And you can see the contradictory approach here. The court is disbelieving 3 nuns, but the court wants to believe another witness who is telling before the court that she had made a false complaint with very horrible allegations against the sister. So that contradictory approach is very evident. And another factor cited by the court is that the fact that this victim and the bishop, they had traveled together and they had attended certain functions. And in the functions, the sister was looking happy and she was interacting in a very friendly manner with the bishop. So this is cited by the court to suggest that she was in some sort of friendly relationship with the bishop. Now, there is one fundamental flaw here. It is important to remember that Bishop Franco had no defense of consensual sex. He had no defense that he was in a relationship with the sister. So if the bishop had pleaded a case that everything happened with consent, then probably these evidence might become relevant facts. I'm not saying that they are still post crime behavior is a relevant fact, but if there is a case of consent, fine, at least to some degree, maybe. But the bishop here, he has no case of consent. He does not put forth a case of consensual relationship. But the court actually is taking up that case. And if you read the judgment, the court is not saying it very expressly, but that message is conveyed in the judgment. And in my opinion, I had also discussion with several other trial court lawyers as well. Everyone was shocked with this approach because the court is not supposed to take a case which the accused does not plead. Court just need to look at the prosecution case. Here, the court is actually pleading a case for the bishop. Court is taking up a case of consensual sex, and court is citing certain instances of bishop and the victim traveling together, and also certain email exchanges to say that they had some sort of friendly relationship. And what are those instances of traveling together? I'll tell you. I'll just explain to you in brief manner. So on 6th of May 2014, the bishop had, in fact, the bishop's visit to Kerala in 2014 was to attend the first Holy Communion ceremony of a relative of the victim nun. So the victim nun's sister's son. It was his first Holy Communion ceremony, and bishop was performing that ceremony. So it is to attend that function that bishop had stayed in the convent on the night of May 5th. So on the night of May 5th, the first instance of sexual crime happened. And on the next day is the family function, where the bishop is the chief priest. He is the chief priest of the function. And it is the function of the son of the victim's sister. So naturally, the victim would be behaving in a normal manner in that function. She may not be happy inside, but she will be projecting a happy face. That is a natural, that is a very normal human conduct. She would not be wanting to spoil her family function by disclosing these things or by even making a gloomy face. And if you see, it is very interesting to note that the sister of the victim nun, she was examined as a witness. So she had told before the court that during the function, she had seen the victim crying at the back of the church. So she felt that because there is one slight backstory to this. So the victim's sister's husband had expired. So even the victim's sister was crying during that function because she said that she thought about her lost dead husband, and those memories made her cry. So when she looked aside, she saw the victim also crying. So when she asked the victim, why are you crying? She said that after seeing you crying, I also felt like crying. So this evidence is a clue to what happened on that day. And this evidence is a clue to what was the state of mind of the victim on that day. Because when nobody else was there, when she was away from the spotlight, when she was away from the crowd, she was crying. And when she was in front of others, she was pretending to be happy. But I'm even a layman, even a common man with a basic, with a certain reasonable sense of discretion, will be able to understand what was the state of mind of that person. But unfortunately, I'm really surprised that the court is not able to see that. A judge is supposed to be judicial. A lot of people during the course of trial, etc. So a judge should be able to understand human conduct. Judge should be able to understand human psychology, how people behave. It's not just about understanding certain provisions and knowing certain precedents and case laws. You should be able to, especially a trial judge, should be able to understand how people behave. So this was one instance. This was one instance cited by the court to say that they had no problems with each other. They were friendly. And another instance is that there is one email sent by the sister. This was produced by the defense. And if you see that email is extracted in the judgment. To me, it appeared to be an email sent with a very official tone. The sister is addressing the bishop as dear lordship, because that is the customary way of addressing it. And she is asking about the activities of the convent. She is telling the bishop to take care of the concerns of missionaries of Jesus. That is the message. On the contrary, the judgment also extracts certain messages sent by the bishop. I don't want to say it here. And if you can see in the towards the concluding portions of the judgment, that is extracted. And from those messages, you get a different impression. It gives out an impression of a person who is behaving very inappropriately. And court is like, so so these instances are enough to give an impression of what kind of interactions they had. It is clearly throwing light to the kind of authority and power which the bishop had over this person. So someone had actually mentioned that the bishop had asked her to iron her clothes. Also, the judgment also mentions another fact. The sister had to carry the luggage of the bishop from his car to the room, to the guest room. And she is the mother superior of the convent as well. So she has to take orders for ironing his clothes and taking his luggage. So this is clear evidence of the kind of relationship, which kind of the authority which the person was having. And in such cases, law says that when a person is in a position of trust and authority, the law says that consent shall be, it should be presumed that there was no consent. That is a law. And it is the burden of the defense to prove that there was consent. They have to prove it. And here, bishop does not take out a case of consent. He does not plead consent. But the court is saying that the court is taking up that case of consent. And that is a very shocking fact, which I felt. Court is taking up a case which even the defense did not have. And Rebecca ma'am was saying that it was a case where the victim was put on trial. I would add to that by saying that it was a case where not only the victim was put on trial, it was a case where the court was taking up the case of defense when the defense lawyers did not have such a case. So yes, so these are the points which I had to make. Rest, Rebecca ma'am has explained it very well, very clearly. So I believe I've taken my time. So I'm now moving on to you.
Thank you very much, Manu Sebastian. Now we have almost 20-25 minutes. So you participants can ask questions, clarifications to any one of the two speakers. You are welcome. Now we have Sunny Fernandez first. Please unmute and speak.
Thank you for this opportunity given to ask this question. In fact, I have had the honor to be on Republic TV on a debate on this particular case. Now, there are three things that come to play because I had recently written an article about 3 or 4 days back, which I posted in this forum because I am a blogger. There are three things. Either there was no rape, or it was consensual rape, or it was rape. There are only three things that can be over here. Prima facie, yes, it is a rape. The fact that Bishop Bulakal did not respond to the court hearings when he was called. Number two, the doubt of consensual rape is the time period taken for the nun to come and prove or to complain to the authorities. Now that is raising serious doubt. So these were the two things that I had brought out in my article which was written. The third, very, very heartbreaking, is the church, the silence of the church in the entire matter. In fact, there was recently a case in Bombay, not recently, it's an old case where now today the priest has been sentenced for sodomizing a child, and the priest was actually being protected by the Archbishop's house. So the anger that is stemming out over here is the church's attitude to this entire thing. So this is what I wanted to present, sir.
Okay, thank you. Then Branile D'Souza. Please.
Yeah, hi, this is Brunel D'Souza speaking, and I have been part of, been accompanying survivors in the church, more recently in a case, and of course this survivor also, but more recently in a case in Bombay, where it was not a case of clergy sexual abuse, but a lay leader who had, abused a young girl, molested. And my question is both to Rebecca and to Sebastian. As the previous speaker spoke, you see so much of reluctance, by the authorities to take cognizance. Even in this recent case, we really had to, negotiate and push. Vrinda was assisting us for 2 months before the Cardinal constituted a committee. So we have a gender policy, we have a sexual harassment we have a policy on sexual harassment within the church based on the POSH Act, but ultimately there are no systems in place. There is no committee in place. And when we kept telling the Cardinal, we in fact quoted the gender policy and the sexual harassment policy of the church and said that you are bound by these policies per se. Also the law of the land to take cognizance of this. There was so much of deterring. And then we said, if we'll go out and complain to the police, and then you will not have an option. We will tell the police that we took the complaint to you and you did not act. So we really need, I think we need the entire community. We need all, and we need, civil society organizations, feminist activists to help us to make the Indian church accountable for from both a preventive, promotive, and, and when cases emerge.
Okay. Any one of you, Rebecca ma'am or Manu Sebastian, any one of you can give an answer. Is Rebecca available? Okay.
Yes. Brunel, I agree with you. I don't think you were asking a question, but I completely agree with you about the inbuilt structures of impunity and the fact that institutions, church, and other institutions are always resistant to self-correct. It is really time for the church to introspect, to take into account the law of the land, and to take into account the fact that women constitute half the members of the church, and they must therefore have their rights respected. I was reading some of the comments on the chat box, and they were mostly very positive comments, but I saw one or two comments which suggested that this case was a false case. And I just want to put something in perspective. When Manu or I or Brunel or anyone else brings out a point, when we are dissecting a judgment and we are saying that the rights of the victim were not protected, we are not necessarily taking an anti-male position, but we are taking a pro-victim position. There's always a victim to a crime, and the victim must get justice, you know? So by saying what we are saying, we are not really saying all men are like this. And I think we need to, I'm presently arguing a matter in the Delhi High Court against criminalization, against the exception to marital rape. And the amount of hate mail I get on a daily basis, I wonder from where this anger is coming from. In case after case, we see women losing the struggle. We are not really seeing women winning the struggle. So there is no need to get hypersensitive. I think what we are simply saying is that the judicial assessment of the evidence was based and premised on faulty considerations. The victim's statement was credible, believable, and therefore there was no need to go into areas that the judge went into. And by saying so, we are merely attacking the individual who committed the crime. We are not going against a particular gender. This is not anti-male. This is not some set of women who've gone crazy suddenly. None of that has happened. So kindly look at this in perspective. Somebody has suffered grievous harm and hurt. It is an offense in criminal law. I would request everyone to show empathy and not look at the victim's testimony with suspicion, because she doesn't deserve it. Thank you.
Okay, thank you. Now, Arav Daniel. Yeah, please unmute and speak.
Yeah, hello, am I audible?
Yes, you are audible.
Yeah, I really want to thank the organizers who arranged this excellent session today. I come from a Marathi-speaking Catholic community from Mumbai, Maharashtra. In fact, I had written an article expressing the solidarity with the nun few days ago, but I was trolled left, right, and center. It was so heartbreaking. But after seeing this, many like-minded people in this webinar today, I'm feeling hopeful for the justice. And as Rebecca ma'am rightly pointed out, we need to have a structural change within the church, because we know how prevalent these sexual abuse cases in Catholic Church are. And I think for that, we need to hold such webinars by eminent legal experts in various part of the corners of India, like in regional languages as well, like in Malayalam, in Marathi, so that it reaches to the ground level where these nuns are working or the other lay people are working. So I wanted to request organizers to form a group where we all can join and take this ahead, or we can even expand it further to accommodate more fellow supporters. And that way we can also raise some financial aid required by this nun to fight this case further. Thank you.
Thank you, Arav, for your very good suggestion. We will seriously consider your suggestion. Okay. Anastasia Gill.
Yeah, can you hear me?
Yeah, we can hear you.
Yeah, I'm Sister Sneha, presentation sister.
Okay, yeah.
Yeah. I first of all, my congratulations to Rebecca and Manu. I'm also a practicing advocate in Delhi. I'm very pleased with both my senior colleagues to have presented a very objective, critical analysis and deep reflection on the judgment and our perspective that we need to take in this present given scenario. First of all, I want to say that we got to work collectively. The negative popularity that Franco case is obtaining right now with fake popularity, what I say is people who are trying to bring out the truth or show solidarity to sisters or to the victim, they are further being victimized. And we've got to, my first point here is that all of us who are gathered here, it's more than 514 numbers I see present. We've got to create a solidarity group. And I want to stress on one point that Rinda has very clearly said what has been brought out into Nirvaya's amendment that has come in. Here, the person in authority has with Franco is person in authority, and here she too is when you are saying person in authority. It's for me a trust relationship. And I want to analyze on that part that right now, the entire judgment, when I'm looking at it, actually, the victim is further being victimized into the entire trial and as well as in the judgment. It's very, very clear. And hence, as legal consultants, legal persons gathered, and also the activists, the church as a whole need to rise. First of all, here, first my suggestion, solidarity for them to get to appeal, financial support for sisters, and we've got to build up across the country solidarity of sisters and priests, lay women coming forward, first of all, to critically looking at it and bringing out the truth. And hence, if need be, even coming out vocally, objectively condemning the vulnerable situation of the nuns. And I also want to remind ourselves, we have a gender policy at CBCI. We have a sexual harassment at workplace. Where do women stand? Because partly documents when it came out at CBCI at the very inception, when we women religious say, where do women religious come? Very sheepishly, the bishops say, we will look at it later. So women religious do not get covered in any of these policies. And now it's a high time when women religious are the workforce of the church, when it comes to catechetical, when it comes to social work, when it comes to any church institutions, it's they who do the work. And hence, if they are not protected, they are continue to be vulnerable, and some by Mother Generals are told by their own congregations in Kerala not to speak, not to raise voice, otherwise will be thrown out of the congregation. So to this sort of consequences in the country, we've got to rise and speak loud and clear truth that needs to be spoken at this hour. Thank you.
Thank you very much. There is already a solidarity group. We can expand the solidarity. Okay. Yeah. Anita Chettiar. Anita.
Yes, thank you. Thank you. Hope I'm audible.
Yeah, you are audible.
Yes. Thank you very much, Rebecca ma'am and Manu. See, in the corporate sector, in the working place, there is an internal complaints committee for sexual harassment. I wonder in which category the priests come. Okay, they take their mass and everything as a job, right? They have the specific period every Sunday, weekly mass, and the faithful very religiously, they go for the mass and they come. If any sexual harassment incident occurs, shouldn't this place of worship, the church, be considered as a workplace of the priests, where the beneficiaries are the people like you and me who go for mass? And if it can be considered as a workplace, quote unquote, then there should be that internal complaints committee, where there should be a board which kept outside wherever the prominently, who are the members of this internal complaints committee with their name, their phone number, with all this requirement of an NGO, a woman. If such a thing is there, I feel that women or whoever is, like even that case of the boy in Bombay, it happened, right? A boy, men or women or even children, minors who are abused, they know whom to give a call to. They know what it is to be sexually abused. Many of us don't know what is sexual abuse. ये तो कुछ नहीं, ये तो होता ही रहता है, हम क्या कर सकते हैं? वो तो फादर है, फादर ने कहा तो हमें जाना ही पड़ेगा, बैठना ही पड़ेगा, बोलना ही पड़ेगा. This is the attitude. So therefore, can we make a very aggressive demand either from CBCI or somewhere that an internals complaint committee be set up in every parish and a board would be put up in a prominent public place for people to see? This is my humble suggestion. Ma'am, Rebecca ma'am, what is your take on this? Thank you.
Manu also can give.
Yes, Manu also.
View.
Yeah.
Okay.
Why don't you say, Manu, take it up? Why don't you answer that? Yeah.
Hello, Anita.
Yes.
So I agree with you. There has to be certain regulations, but the law as it stands now, it does not cover religious places and places of worship. So you wanted church to be read as a place of work of the priest. But present law, it does not support that, but there should be certain changes in the present law. And I believe a petition is pending in the Supreme Court, seeking to bring not just Catholic institutions, all religious places of worship, ashrams, monasteries, etc., under the ambit of POSH. And that petition is pending. But I'm not sure if the court will be able to change the law. But there has to be certain legislative interventions, and there should be a campaign for that. I completely agree with you.
Yes.
Manu, notwithstanding the fact that the act may not strictly apply to a religious place of worship, nothing prevents a proactive church from forming an internal complaints committee. There's no prohibition.
Right.
The long arm of the law may not extend to the church, but there is no prohibition. In fact, I would say, in the interests of transparency, the church wants to reform itself.
Yes.
It should be one of its fundamental, it should look at this very seriously because it affects a large majority of people. So notwithstanding the fact that the act may not strictly apply within a church, and you may not be able to argue that the priest is coming to his workplace, but if you have a transparent policy of against sexual harassment, and you have an internal complaints committee with members who are notified, nothing prevents the church from following the same pattern that is given, that is incorporated within the Sexual Harassment Act. So I would in fact ask the church to go ahead, notwithstanding the fact that they are not under a legal obligation to do so, but this would only show that they are serious about tackling such like incidents.
Okay, church can be proactive, but it is $1 million question. Kochurani Abraham.
Thanks to both Rebecca Ji and Manu for the excellent and clear presentation. I have two questions to ask and an information to share. One question is to either of you. See, I belong to this group, Sisters in Solidarity, that was started 3 years ago. and we have been accompanying the survivor sister and her companions very, very closely. So, having followed the procedures, since none of the witnesses had turned hostile, the survivor herself and all of us were expecting definitely a verdict in her favor. So it was a shell-shocking experience suddenly to see the table turned upside down. No? So I want to check with you, is there any manner in which the prosecution could foresee what was happening and, take a different course, if at all? Because the prosecution also apparently were believing we were going to win the case. So it was so shocking for the survivor. I want to speak her mind. Second question is, both of you have mentioned there is a very serious offense to the law of the land in this judgment, because it has not considered the way the rape law has evolved since 2013. So what steps are you, not you, I don't mean just the lawyers, but what steps can the civil society, along with those who sincerely want justice, what can we do to prevent such verdicts in the future? Can this verdict be a turning point to address that? These are my questions, and my information is for all those who really want to be in solidarity. The chat is disabled, so we cannot put our mail IDs now. We have a campaign already begun to address. We want to address this issue very seriously in the church. We have already drafted, some of us who are here, we have drafted a document that will be out in a couple of days. We want very many people, we want you to circulate. This is for Catholics. Okay, we want you to circulate to other Catholics in your place, in your contact, so that more people, more voices are gathered to address these issues within the church.
Kochurani, the chat is enabled. You can give the email ID.
Okay, yeah.
So any one of you can.
Manu, you probably have a better sense of ground realities than me, because so could you answer the first question as to whether the prosecution had any advanced sense of what was happening in the matter?
See, one thing in the case was that there was a media gag. So the reporting of the court proceedings were banned because there is a provision in the CRPC itself for in-camera proceedings in rape trials. So the public had no knowledge about what was transpiring during the evidence or the trial. So we can't comment about what really happened during the case. But what the impression which we gather is that the prosecution was quite confident about success. And even this came as a shock to them, because that's why after the verdict also, we saw a very shocked reaction by the investigating officer as well. And that is quite unusual for an investigating officer to, he was quite emotionally reacting to the verdict. Because see, this was a case where the victim had come and it was supported by 3 other nuns. So they must have thought that it's a quite fair, solid case because it was corroborated as well. And maybe it must have been a shock for them as well. And I believe your second query was regarding how to prevent such verdicts, I believe. Maybe, we don't know, maybe we should, there's an element of sensitivity as well, I believe. So judges should show that sensitivity. It's not just about your legal knowledge. And you should be able to understand how people behave, especially survivors of sexual crimes, how they behave. And so that gender sensitivity element should be also there. It should not be just mechanical. And when you see the evidence, you should see it in its totality and not just in its separate categories and you discredit one, discredit two, not like that. You see it in its totality and your holistic sense. So maybe some sensitization should be there. Recently also there was a judgment by the Supreme Court. So this might be interesting for the audience as well. There was a judge in Madhya Pradesh, in a sexual harassment case. while granting bail to the accused, the judge imposed a condition that you should go and meet the girl and get a rakhi tied from that girl, so that you will be her brother and you won't harass her further. This must have been the judge's indication. But just imagine the trauma of the girl, who has to see this person coming again, and and this was appealed before the Supreme Court by a group of lawyers, and the Supreme Court set aside that judgment and issued a lot of guidelines how judges should deal with rape cases and sexual harassment cases, that they should not fall into these stereotypes, rape myths, and there are a lot of stereotypes about how women will behave after a sexual crime has happened. We might be seeing it in our movies and or like very dramatic reactions, etc. But that may not be happening in real life. So someone had during the session itself, the person had mentioned that some people, they just get frozen after the incident has happened. They may not be in a position to react. They might become frigid out of fear. Such reactions are there. So these things only there are persons who study these reactions. There are psychologists who study such reactions. So there should be an endeavor to impart such training to judges as well. So I believe that is my suggestion. Over to you, ma'am. Rebecca, yeah.
No, I think you've covered it all. You've answered it very beautifully. On the issue of sensitization, I think judges need as much training as ordinary lay persons, because sometimes they forget that there are lived experiences which need to be respected. And lived experiences of survivors of sexual assault is something that requires a very special understanding. You cannot, as Manu very rightly said, you have to look at evidence holistically, and you can't look at one contradiction somewhere here or there and then decide the fate of the case on the basis of that one contradiction. You must also always preface your views with, you must always have an understanding that these are sexual assault cases where there will be memory losses, where there may be some inconsistencies that will happen to anybody. If you ask yourself a question, what you did from 6 a.m. in the morning to 10 a.m. in the morning in chronological sequence, you'll find yourself faltering. So to expect a standard from a witness which is not a human standard is also not right. So that is why judges are trained to look at evidence holistically. Unfortunately, that was not done in this case, and it has resulted in the decision that was finally made. So definitely, more than anybody else, judges require training in cases of sexual assault. Something a former Chief Justice of the Delhi High Court did periodically, Justice Geeta Mittal, and Manu would be aware of that.
Dear friends, there are 4 more persons to ask questions, but we don't have time. You can contact these speakers later through mail. We will make available to you all the email IDs of these 2 speakers. Now I invite Sister Shanti to propose vote of thanks.
Good evening, friends. Am I audible?
Yes, you are audible.
On behalf of the National Forum of Religious for Peace and Justice, I take this opportunity to thank the speakers of the day, the renowned advocate Rebecca Mammon, criminal lawyer of Supreme Court, for being with us. Madam, thank you for sharing your views on Franco case, critical assessment of the judgment. Ma'am, you spoke openly, freely, frankly, without any hesitance or fear on what the Supreme Court has been saying about the testimony of rape survivor and how it is different from other witnesses. Having 34 years of experience as a criminal lawyer, can say that the court fell in error and has failed to give justice. You have enlightened us on how they have dissected the whole matter. We are enriched by your explanation, which had clarity, And this will motivate us to work for justice. We appreciate all the trouble you took to study the topic in order to share on it, giving examples. It is shocking to see how the woman is discredited and completely disregarding section 376F. Moreover, the rape survivor was on trial instead of the accused. Thank you for clarifying our doubts and giving us suggestions to challenge the existing structure of the church. Once again, thank you, Ma'am Rebecca, for the excellent presentation, giving us the flaws in the judgment. We will work at institutional systematic change. Thank you, Sir Manu Sebastian, Chief Editor, LiveLaw.in, for sharing with us some of the fundamental problems in the judgment. For example, in the beginning itself, you said, no person can completely explain what exactly happened a few years ago, some time ago. The court has failed to extract the truth by completely disbelieving the victim and witnesses. You have really studied, analyzed the judgment critically, and you explained how the court has failed to give justice, how biased it is, by giving several examples from the judgment itself. Thank you very much, sir, for your effort to make things clear for us. Very clearly you explained how the statements of the victim and of our witnesses are systematically discredited. It's quite sad that such a thing is happening in the 21st century in independent India. But surely it is challenging us to fight for justice. Thank you, Sir Manu, for clarification of doubts and answering the questions. Thank you, Father Jacob, for facilitating the webinar very, very meticulously. Thank you, Sister Dorothy and the team core committee members for organizing this webinar so quickly. Just the other last week we had the meeting and so fast it was arranged. Thank you very much. Thanks to all the participants. I saw the number was almost reaching 500. I think above 500 it must have gone. I don't know. Thank you, fathers, sisters, and all those who have taken interest to participate in this. We have come in large numbers. I'm sure everyone is enlightened and enriched. We have a long way to go. We can work together for justice. So now this shows that we are aware of the patriarchal mindset of authority in our country. So let's work hard now. Thank you once again. Thank you one and all.
Thank you very much, Sister Shanti. In fact, you have summarized the whole thing. Okay. We have recorded the whole program. Those who want the record can contact Sister Dorothy, the national convener of the Forum of Religious for Justice and Peace. Thank you. Thank you very much. So we are going to close. Thank you very much once again for participating in the webinar.
Thank you, Celia. I hope you found it good. You found it good?
Yes, yes.
Yeah.
Found it good. The other talk, what was it? Why he was but there is not just this part. Both are telling two parts. So both I have attended.
Oh, okay.
PMI arranged, no?
Yeah, yesterday, yeah.
Yes. Okay, we'll talk later.
Yeah.
Thank you, Sister Dorothy.
You're welcome.